Welcome. I am attorney Amanda Schaefer. Today, doing a little something different. Issue popped up or has been popping up that I wanted to talk about because it's a problem for a lot of people out there. So, no fancy graphics today, no fancy presentations, just me talking live about what's going on in the justice system. So, if you are a non-custodial parent paying child support pursuant to a child support order, whether it was after a trial and the judge ordered it, or you entered into an agreement with the custodial parent and then the judge entered it in a court, so ordered it, you have a child support obligation every month or every other week or every week, depending on what it is. You have a child support obligation. Certain percentage of your income is supposed to go towards child support as the basic child support obligation. You also may have add-ons such as your pro rata share of extracurriculars, of camp, college expenses, medical expenses as well. So this applies kind of across the board. And it's really important. There's things that people paying child support have no idea of, and this is why I'm talking about today, because this has came up in a few of my cases. So, number one, a lot of times people don't have attorneys representing them in child support proceedings. You do have a right to an attorney to represent you. You don't have the right to a free attorney unless you're facing incarceration for a willful violation. But you have a right to pay for an attorney if you so choose. And you just tell the judge, and then they adjourn it, you get an attorney, you come back the next day. That's number one. And people don't know that. And that's incredibly important. Number two is that if you miss court and you're the non-custodial parent, you might not get a second chance. You might have an order of default issued against you. And that order, if they don't have your full financial picture, you couldn't explain it. And this is, for W-2 employees, might not be as big of a deal as opposed to someone who's self-employed. You're not going to have control over the number the judge puts down on the paper, whether you can afford it or not. So don't miss court. If you're watching this from another country, in a different time zone, triple check the time. If you have an attorney, your attorney should help you with that. But if you don't, and you're just appearing pro se, check daylight savings. Just check, like on this date, because you can literally Google it these days, or chat GPT it, I guess, if it's up to date. But you could say on this date, it will be this time if you're in a different time zone, this time in my time, what time will it be in New York or wherever your court is. And everything I'm saying today does apply to New York. I've always say the family court laws are similar in other states, but you do want to check your specific state rules because they may be slightly different. So the next thing you want to know is that if you do not pay your child support, actually, before I even get to that, once there is an order entered by the judge, a final order of support, you have 35 days to object, which is kind of like it's not going to the next level, to the appellate court. It stays on the trial court level, but instead of a support magistrate, it goes to a judge. And so it's a different person, and they look at your objection. That is, if the objection is denied, it's appealable. If you don't timely object, you may lose out on your ability to challenge the decision. During the objection period, unless you had I don't even know actually if the court can grant a stay of the order, but unless you ask for it and are granted a stay of the order, the objection alone does not stop the order from going into effect. So if you're ordered to pay $5,000 a month in child support, which is a lot, and you can't pay it and you file the objection, that's still going to start accruing against you if you're not making payments. You pay what you can. You always want to make payments that you can once you child support, even if you can't pay the full amount. And you always, if you are paying and then something happens, like you lose your job to no fault of your own, or God forbid you get injured, you want to file modification petition immediately, because it backdates when you go through the modification process. If you win, it will modify it backwards. So it goes back to the date you filed. So if you wait a year to file, then that full year where it was $5,000 a month, but it should have been $1,000, you're still going to owe $5,000 a month. It will only go back to that date you filed. So very important to stay on top of it. The next thing is that you want to really make sure that the court and the child support collection unit has your up-to-date contact information. That means mailing address, that means email, that means phone number. This is true no matter where you live, in New York, in New Jersey, Connecticut, California, Turkey, China, it doesn't matter. If you move or your contact information changes, tell the court, because they're going to be mailing notices to you. Now, not all child support cases involve the child support collection unit. You're going to know if yours does, because it will say it in the order, and you'll get a CSMS number. The court will forward the order to child support collection unit, and they're an enforcement agency. They're going to make collections, and they can impose consequences and penalties on you if you fail to pay your child support. And that's what I'm going to get to in a second. Now, even if you live outside the country, now I have a situation going on right now with a client who didn't have an attorney, and he was asked to give his U.S. address, but he didn't live here. So, but he got pushed by the judge to give a U.S. address. He did. It was a friend, but not a friend that he is going to tell him to open his mail. And now we have a problem because he didn't get mail his friend wasn't telling him he was getting the mail. How can this be resolved? Well, you can designate someone to be your agent for service. Technically, you can, I believe, designate the Secretary of State, so they'd mail it to Albany, and Albany would send it to you. If you have someone you can trust in the state of New York, specifically if you're in New York City, or whatever county you're in, or you want someone local, that is always better. And you tell them, they might, if you don't want them to open your mail, not a problem, but they should promptly notify you of anything that comes in and make sure you get it, because they're not going to be on the hook if you miss court or you miss a payment. You are. This is your responsibility. So you really need to make sure that you have an address, an email, a mailing address, and phone number on record with the court that is accurate. The court generally asks you at every appearance to confirm your address. It is not a bad idea to also check the orders when they come out to make sure the correct address is on there. And if it's not, you promptly notify the court to make the change. Same with this child support collection unit. Because here's what can happen. After 4 months of not paying child support, and I'm not talking about arrears or retroactive support, just the child support, your driver's license can be suspended. The child support collection unit will send you a notice. It's basically saying you have 35 days, I think, or 45 days to challenge the suspension. There's very narrow channels in which you can challenge the suspension based on, but there are legitimate reasons that you can challenge it. If you do challenge it timely, you can get the suspension stayed. It also gives you a chance to make a lump sum payment or enter into a payment plan to avoid the suspension of your license. If your license gets suspended, you may be eligible to apply for a restricted license, which basically allows you to drive from work to home. So you might be thinking that's not, the worst case scenario, but what if you're an Uber driver? What workplace are you putting down? What if you are a salesperson who goes to different clients? What workplace are you putting down? There's plenty of people out there who do not have just one work site, and the DMV can be very difficult about only providing one work site. So you want to avoid the restricted license altogether, and the first step is making sure you get notice, because if you don't get notice, you're not going to know it's going to be suspended. Why am I wasting my time? Not wasting my time, but why am I spending my time talking about all of this? Because of how dire these consequences can be, especially if your job depends on driving. You lose your job, and either you're going to have to get a job that you don't want or doesn't meet your qualifications just to make the child support payments. If you're here on an immigrant or a non-immigrant work visa, or immigrant work visa for that matter, you may have to leave the country if you lose your driver's license, if your job depends on it. And of course, if you lose your job, you're not going to be able to pay the child support payments, making your problem even bigger. So what can happen is if you don't get notice and you challenge the decision late. Now, there is a provisional law that says if child support unit sends you this notice, and let's say they send it to the wrong address, so you didn't receive actual notice. When you finally find out, it's because your driver's license is being suspended. And that's it. You can still challenge it. And I've been in this situation. And child support collection unit will say, this isn't a timely challenge, we can't consider it. Go talk to the DMV. So you go to the DMV, and the DMV says, oh, you can get a restricted license, but we can't do anything else about it without a court order. So you get a restricted license, but depending on your situation, it might not even change your situation. So you go back to child support collection unit, and they tell you, well, it's not up to us, it's up to the DMV, or we need a court order. Okay. So you go back to court, and you tell the judge. And the judge says, I can't do anything about it, I didn't order it. You need to go back to the DMV. And you get into a cycle of repetitiveness, of everybody telling you that it's not their problem and that you need to go somewhere else. And as an attorney, this is the frustration I can't even tell you. As far as I know, the judges have certain powers they don't have. One of the powers they have is to correct injustices. And it's my belief that this would be an injustice if someone didn't receive actual notice of it. But it doesn't necessarily mean that you're going to walk into the court and the judge is going to be like, oh yeah, I know that provision of law, you're right, here you go. What's more likely going to happen is this is actually a much more obscure part of the law than you might think, and it happens a lot more common than you might think, because there's a lot of people that don't even realize it. It's almost like automatic, because if you have a driver's license in the state and 4 months go by, actually, it's not just 4 months, it's your arrears end up totaling 4 months or more, like you might make one payment in the 4 months, that's not going to stop this. Then it'll just be an extra week if the extra week of accrual of the child support payments. So once there's in total 4 months worth of arrears, so 4 months worth of payments not paid, then that's when this driver's license suspension may kick in. Child support collection unit doesn't have to go back to court and file anything. They don't have to prove anything else. You get your chance to challenge, and that's it. And then it goes to the DMV, license is suspended. Getting that suspension lifted without paying your arrears in full or entering into a money judgment and a payment plan. And when you enter into a money judgment, 9% interest and possibly other fees involved. If the other party has an attorney, might even be ordered to pay attorney's fees. You're facing a really difficult situation. One thing that you learn as you practice is that no one's perfect, whether it's attorneys, clients, judges, and there's a lot of laws. Been doing this for over a decade now, and I still find things in the laws that I didn't realize were there. These, especially if you're talking about child support statutes, they're like that, like you're scrolling down the page, I can't even show you how long the page is for some of these provisions. They're confusing, they're hard to read, they reference a lot of other laws. A lot of laws are written this way. I don't know, I don't write the laws. But the point is that there's a lot of things in there you might not realize. So you really, of course, want to make your child support payments on time and in full. If you can't make the payments for any reason, you want to immediately file a motion for downward modification. Now, keep in mind, if you enter into a settlement agreement, you may limit what you can file this motion for modification based on. But everybody can file based on a substantial change in circumstances. I'm not going to go into a full explanation of the difference right now, but what it's not, a substantial change of circumstances, is not you quitting your job or because you didn't like it, or you getting fired for cause, or you cutting back your hours because you don't want to work as hard. Anything that's within your control is not a substantial change in circumstances, and you're going to also be looking at a possible willfulness finding, which could not only have your driver's license suspended, could subject you to incarceration for up to 6 months, and in fact, you might not get let out until you make a lump sum payment. You don't want to be in this situation. You got one thing to understand about arrears for child support is they are almost impossible to vacate or annul or modify. There are situations, very narrow situations, where that can happen, but for the most part, you're stuck with it. So you want to make sure that you don't miss court so that you can put your argument forth to the judge on what your income should be considered for the purpose of the calculation, because it is a formula, but even after the formula, the judge can increase or decrease the amount based on the facts and circumstances of each case. So you might not have a lot of income, for example. Let's say you make $100,000 a year, but you own 4 properties. The judge can decide that some income can be imputed to you, and instead of $100,000, your income be based on $150,000. If you're not there to say, to object to that and to present evidence that this $50,000 extra dollars isn't coming from anywhere, you're going to be stuck with it. And if you had agreed in a settlement agreement for some reason to pay a child support amount which is more than you can afford. And you might be thinking, why would that be? Why would you ever do that? Well, it happens more than you think because lawyers are expensive and people don't want to go to trial, so they settle on terms that are not in their favor. Do they regret it later on? Yeah, I'd say so. At least the people I've encountered. But people don't necessarily grasp the fact that they're really stuck with this order. And not only that, when they enter into this stipulation or an agreement, they're even more stuck. It's even harder to change because if you try to tell the judge there's something wrong with the order, the judge is going to say, well, you agreed to it. Even if your back was against the wall and you had no choice, you agreed to it. I'm not saying you should go to trial always in that situation. I'm saying don't tell yourself, oh, it's, just get done with this now and then, next year I'll have the court change the order. Not going to happen. If you can tell, frustrated. I've been dealing with a lot of cases this week where I felt, this week and last week, really the past few weeks, where I felt my clients were treated unfairly, especially when it comes to child support situations. And this starts with the law itself. The law itself is so unforgiving. And look, don't get me wrong, I'm all for paying child support. I think that every parent I know they have a duty, but I also think that every parent should support their child and should want to. And it's really important that you do because our country suffers when, our economy suffers when child support payments aren't being made. But of course, if an amount is entered that you can't afford, you can end up ruining your life. Not just having your license suspended, not just incarceration. We're talking wage garnishment. We're talking professional, recreational licenses being suspended. We're talking never getting your tax refund again. All of the above. You can't file for bankruptcy. You can file for bankruptcy, but it's not going to affect that you owe the arrears. You're always going to owe the arrears. And once that gets put into a money judgment, now you're looking at interest on top of the arrears. So it's really crucial that I really hope this video gets shared and saved and whatever else people do with the positive things people do with the videos to get it in front of other people, because there are so many of you out there, I know, because you call me, that just really don't know this, and not everyone can afford a lawyer. And unfortunately, in child support cases, you don't have a right to a free lawyer if you can't afford one. You have a right to a lawyer that you pay for. If it's a hearing about willfulness, about your failure to pay, and facing potential jail, then you have a right to a lawyer, period. Whether you can afford one or not, they will appoint one to you if you can't. So you really need to prioritize making these court appearances. You cannot assume the court will give you another court date and not enter a default order. If you do miss the court for whatever reason, you want to immediately notify the court. The minute you realize you've missed it, tell them why. And then you're going to want to file a motion to vacate. And this can also be confusing because when you get the default order for when you miss court, it says in big capital letters on top that you have like 33 days, 35 days, whatever it is, to file an objection. And then at the very bottom, they usually put in a footnote that if you're filing to vacate, if you're filing based on the fact that you missed court, you must file a motion to vacate. So if you file an objection, then it's not the right procedural vehicle. You do have up to a year to file for a motion to vacate, but you need a reasonable excuse. And like I said, just like if you file an objection, the child support order is not stayed, it takes effect and you start owing money. And not only do you owe money going forward from the date that the custodial parent filed the application for child support until the day the order is issued, all of that is now going to backdate. So you may have been paying a temporary order of like $50 a month, and if now the final order of support says you're paying $100 a month, you're suddenly not up to date in your child support payments, because if it took a year to get to that point, for a full year, you only paid half of what you owe, and that's going to be tacked on to your monthly or whatever frequency of your obligation is. So that, again, is really important that people understand that. I'm going to say this again. If you move, do not think for a second that the judge will not, I'm sorry, not the judge, that the child support collection unit will have any idea unless you tell them. You have an obligation to notify them of a change of employer as well. And this is especially the case if you have an income withholding order, because then they have to contact your employer to get the payments. If you get into a situation where you didn't receive proper notice of either a hearing or of a suspension, well, then you really, it's advised you have an attorney from the beginning, but that's when you even more so want to have an attorney. But we are limited by the law. And as I was saying, I definitely advocate for the payment of child support 100%, 110% for that matter. But what I don't like about the law is how unforgiving it is when it comes to child support. That unless you can prove that the order is unconscionable, which basically means that it's like so unreasonable that no reasonable human being would agree, or not even agree, no reasonable judge would enter that order, or there's a mistake of law, a mistake of fact, you weren't actually served and you can prove it, unless you fraud, you were tricked into agreeing or tricked into something. Those are the misrepresentation. Those are the types of grounds that you can fix your arrears with. But it's incredibly narrow, even narrower when you've entered into that stipulation, and you're going to spend a lot of money on attorneys to get to those intricate points of law, to find them, argue them, and judges do not like to vacate child support orders. They're more likely to modify them than they are to vacate. But when you file to when you file to modify, even if you win, your arrears from before you filed the petition will remain. So if you get yourself into this situation, as soon as you find out that you failed to pay or you missed court, you need to start taking action. Don't wait. Don't rely on what anyone tells you unless it is a lawyer that you have consulted with and or retained. The judge is not your advocate. They have certain duties and certain responsibilities when it comes to the information that they're supposed to tell you. If you're not in court, you're probably not going to get that information. But they're still not there to do a lawyer's job for you. The Child Support Collection Unit, the DMV, they are also not there for you. They're not on your side. When people don't pay child support, there's a very negative stigma attached to that fact. And all they're going to see is that you didn't pay. And you're going to be digging yourself out of a hole from there on. So you want to avoid getting to that part. This is an area of law that I really wish the state legislature would change. And one of these days, if I put myself on the matrimonial committee or the family law committee in the New York State Bar, I would definitely push for this change. Right now, I need to get some help over here before I can do stuff like that, which I would love to do. But everyone out there watching, complain to your congresspersons, your state representatives, your New York State representatives, New York State senators about this law and how unfair it is. I mean, you know what's unfair? That they put you in jail until you do a purge amount. A purge amount can be any particular amount. Sorry, Instagram, that thought I had my phone on do not disturb. And what's also not fair is the arrears portion, because if it turns out that the decision was wrong in some respect, or you missed court and it really wasn't your fault, or you didn't receive a notice of something, it should be a little bit easier to fix. Everyone should pay their child support, but everyone should also only have to pay a fair amount of child support, not more, not less. So, I'll end my little rant here. But essentially, just to recap, what I want to get across, and what I hope everyone watching out there can share this with others so that they can also hear this information. Number one, take court seriously. Do not miss it. If you have to miss court, you want to notify the court as soon as you know you're not going to make it. This is even more true if you don't notify them in advance. You want to notify them, and you want to, if you can, have any documentary proof of why you missed court, like if you're in the hospital, something like that. But don't miss court unless you have to. Check the time. You can, New York, if you just Google New York court case lookup, you can type in your name and find your case. All right, actually, in family court, you might have to put in the docket number or file number to find your case, but it's there. It's always there. You can also call the clerk and ask. Know that if you're in a different time zone, you're aware of that. I know I've been in a different time zone, and I've done a virtual court, and then I've scheduled the next hearing. Like I was sitting in front of the computer. I had my phone and my calendar. I put in the time and the date, and then I get back home to New York and I look at my calendar and it's like 3 a.m. I'm like, did I make a mistake when I typed it in? And I'm like all confused. And then I realized it was because I was in a different time zone. So it entered it at the time New York. So it was, I don't know I don't know where I am at 3 a.m. Wherever I was, let's say I'm in California. That's easy. 3 hours early in California. So if I'm in California and I say that court is going to be in New York at 3 p.m., when I get home, it says 12 p.m. because it enters it based on the time zone you're in a lot of times. Not every calendar. You may have done something to not have this happen, but make sure of that. I would write it down by hand. I would also record it somewhere on a calendar, on your phone, computer, wherever. You also want to make sure that once any case starts in the family court for you, whether it's a child support, custody, paternity, visitation, anything, once that happens, even if your case ends, you must notify the court of your updated contact information, your address, phone number, email. Because if a new case starts up and they serve you at your last known address, not all cases require personal service. Personal service requirement can be waived by the judge as well. You might not get a notification, and it's going to be on you if you didn't update your address. If you don't have an address in the US that you have someone that you can trust with your mail to not just hold on to your mail, but notify you if something important comes, then you should ask to designate someone as your process server, whether it be, not process server, I'm sorry, agent for service of process, whether it be the Secretary of State. I honestly didn't look if you can do that. You can for certain things. I don't know for all things, but even if it's an attorney who you hire just to receive your mail and send it to you, that's not going to cost you much no matter who the attorney is. It is worth it because if you miss it, you can cause yourself some real problems. And the court is going to forward all the information they have about you to the child support collection unit. And they're going to send you important notices about your case, about your payments. And you want to make sure when you get those notices, even if it's not because you missed it, if it's just an accounting, they send you like every month an accounting to show what payments you made. Like they'll say what your basic support is, what payments they received from you, what payments were dispersed to the other parent, and what your balance is. And if you don't receive those notices, then and you default in paying or you're not paying the right amount, you're going to have bigger problems. But you also should be doing the math yourself when you get those each month and make sure that they have accounted for every payment you made, because they make mistakes. They make a lot of mistakes. And you're going to be on the hook for their mistakes, unfortunately. So you need to look out for yourself, and you have the right to contest it. You have the right to ask for it to be fixed when it's wrong. But if you don't act timely, you could waive your rights sometimes, or you may limit the amount of time that you're able to get money back. Or sorry, not get money back. It's a Thursday afternoon, I'm tired. You can limit the amount of time that the modification, if the big one is in effect, and you end up paying more than you should. You're not gonna because of the retroactive arrears. So we are dealing with a broken justice system with some really unfair laws when it comes to child support payments. And the only thing you can do to protect yourself is to be proactive. Don't wait for a problem to arise. Try to address it in advance. Of course, if you can afford a lawyer, highly recommended that you do. And stand your ground, stand strong no matter what. I like to believe that justice is always served and that the truth prevails. But sometimes you got to fight hard for it. If you lose in court and you don't believe the amount is right, you can appeal it. Appeals are not fun. They're not generally cheap, nor are they easy, nor are they appropriate in every case. but they are an option. And sometimes you just got to do what you got to do and fight as much as you fight every avenue you can, because this is a debt that will stay with you your entire life and will pass to your estate when you die, if you have not paid it yet. So if you need help with your child support case, family case, immigration case, YouTube and Facebook are contact information scrolling across the bottom of your screen. On Instagram, if you go to our bio page, you can find us there. Please don't forget to like us, follow us on Facebook, YouTube, Instagram, wherever you are watching, so you don't miss any more of our lives. I hope I don't have to do another live like this soon, where I'm just exasperated and frustrated and tired and fed up with the system because I don't feel my clients are treated fairly. And the first step to being treated fairly is to be on top of it and to, again, not react, but act. So that is all for today. Thank you all for watching and have a great day.